Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a really important new case that's heading to the Supreme Court of Canada. It's a landmark case about whether Indigenous self-governments are subject to charter scrutiny. The charity that I work for, the Canadian Constitution Foundation, is an intervener in this case. The case is brought by an Indigenous woman, Miss Cindy Dixon, against her band in the far north of the Yukon, Vuntut Gwitchin First Nation. Miss Dixon wanted to run for band council, but her band rejected her candidacy because she lives in Whitehorse, not on the settlement land of Vuntut Gwitchin. So Miss Dixon brought a charter claim for discrimination against the band. Now, it's important here to know that Aboriginality residence is a basis for a Section 15 charter claim for discrimination. However, the Yukon Court of Appeal found that the charter does not apply to the acts of self-governing First Nations because of a little considered section of our Constitution, Section 25 of the charter. The Supreme Court will now consider whether the charter applies to Indigenous self-government. Here today to discuss the case are the two lawyers representing the CCF in the Supreme Court intervention, Bryn and Jesse Hartney, both of McCarthy Tétrault. Thank you both so much for joining me. Bryn, let's start with you. What more can you tell me about the background of this case that we need to know about?
Hi, Christine. Great to be here. So this case relates to a self-governing Yukon First Nation that's located about 800 kilometers north of Whitehorse. The First Nation is no longer under the Indian Act because they reached a modern treaty and self-government agreement with the governments of Canada and Yukon in the early 1990s. So after they did that, they adopted a constitution and they amended the constitution in 2006 to add a residency requirement that stipulated that candidates for chief and council that do not reside on settlement lands have to relocate to settlement lands within 14 days of election in order to serve on council. Ms. Dixon didn't feel that she could do this for reasons primarily related to her son's health and brought a charter challenge under Section 15, as you mentioned. In the decision under appeal, the Court of Appeal found that the residency requirement did infringe Ms. Dixon's charter rights under Section 15, but that Section 25 shielded the residency requirement from charter review. So Section 25 of the Charter provides that rights and freedoms guaranteed under the Charter shall not be construed so as to abrogate or derogate from any Aboriginal treaty or other rights and freedoms of Aboriginal peoples. In this case, the Court of Appeal found that this completely shielded the residency requirement from Charter scrutiny, which, if upheld, could have significant implications for the Charter rights of Indigenous Canadians vis-a-vis decision-making by Indigenous governments.
It's a really fascinating case. I think we'll get more into Section 25 and how little consideration it has actually received from various courts and what the language of it and history of it can tell us. But I want to talk a little bit more about what you raised about her son's health. So as you said, Bryn, Vuntut Gwitchin is in a community about 800 kilometers north of Whitehorse, and Ms. Dixon lives in Whitehorse for reasons related to her son's health and other reasons, including socioeconomic reasons. Jesse, what more can you tell us about that?
So the facts of the case are particularly unique, but as you say, and as Bryn said, it's a circumstance in which, Ms. Dixon essentially is saying, I live, off the settlement lands, in part because, her son has health reasons, needs to be near a hospital, and there is no accessible hospital on the settlement lands. So she says, in order to ensure proper health of her son, and as you say, other socioeconomic reasons, she has to live off the settlement lands. But according to her claim, right, that doesn't mean she doesn't want to be involved in the governance of her First Nation, and that's why she wanted to put herself forward. But ultimately they said, unless you relocate, you can't be a candidate.
Relocate within 14 days. And I think she had refused to agree to do that. I believe that the community is largely made up of a town called Old Crow, which
It,
I've heard is or I've read is the only fly-in community
yeah.
in the Yukon. So it's quite remote, and for a person with special needs for their child, I can understand their concerns about a child with a disability living in a fly-in community. We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing a new case that considers the question of whether the Canadian Charter of Rights and Freedoms applies to the actions of self-governing Indigenous governments. Bryn, I think a lot of people might be surprised by this case. I mean, aren't there any other cases that have applied the Charter to the conduct of an Indigenous self-government? Has this never happened before?
It's a good question. I mean, there are numerous cases that have applied the Charter to the conduct of First Nations bands under the Indian Act and to the Indian Act itself, but not to First Nations that have negotiated self-government arrangements with Canada and provinces and territories. You know, it's surprising that this issue has not come up earlier, but most First Nations in Canada are still under the Indian Act. And it's a much smaller number of First Nations and Inuit that have negotiated self-government arrangements.
So, do you think in the future we might start seeing more cases like this of challenges brought by band members to the conduct of their bands when they're self-governing? Bryn?
Yeah, I mean, I think so. Like, but I also think in uh, this case goes beyond uh, First Nations that have negotiated self-government arrangements, because any First Nation or other Indigenous group that asserts a right to self-government could say that Section 25 shields their decisions from review, even if they're under the Indian Act. So, in the cases under the Indian Act, and I think that those cases will continue to be brought, this Section 25 issue hasn't been really asserted. But if this case is upheld, um, it could be asserted, and so you could see it, this issue coming up both um, with Indigenous groups that have self-government arrangements and also First Nations under the Indian Act.
I want to talk about what the consequences of upholding this decision would be. Jesse, if an Indigenous self-government is immune from charter scrutiny, what could that mean for the rights of the Indigenous people living under that type of government? Can you give some examples of why the non-application of charter protected guarantees and freedoms, why that should be concerning to people?
Yeah, so there's a couple things I should say at the outset. The first thing is that, of course, what it means from a strictly legal perspective is that you can't bring a charter claim for the rights that are found in the charter. That doesn't mean that an indigenous government would necessarily trample on those rights,
Of
right?
course.
So it doesn't mean
Yeah.
that, and it certainly doesn't mean that they can't implement their own human rights norms. In the case of the First Nation that's at issue here, they have a constitution with rights and freedoms, but there's no requirement to do that, and other governments might choose not to, as is the case, for example, in Quebec. They have the Quebec Charter. Other provinces don't have the same thing. So it doesn't mean that you lose your rights necessarily. What it means, though, is that you don't have constitutional rights. You can't bring a constitutional claim. And so, for example, that would mean the right to search and seizure. You would lose that. So the government, the Indigenous government, if they have a police force and they're looking to enforce their laws, maybe they're not subject to the right to silence, to all those other rights, right, that we deal with in the criminal justice system, which are really core to what's in the charter. So in theory, you would not be able to bring a claim to vindicate those rights in the courts, which would be quite dramatic when you think about it.
Bryn, is there anything you want to add to that concern?
No, I mean, I think Jesse has articulated the concern well. Like, it's just that there are a lot of, when you step back, there are a lot of rights within the Charter that could be at stake for Indigenous peoples, and that they wouldn't have um, access to the Charter to kind of vindicate those rights in the event that there were an issue, which I think is significant as more and more Indigenous groups become self-governing and kind of expand the scope of their authority.
Right, just as we should be skeptical of any government, whatever government it is. And that's why we have constitutions to protect those fundamental freedoms that are laid out in our charter. And those are rights that all Canadians are deserving of, at least in my opinion, which is why we're participating in this case. We've got to go to break, but when we come back, I want to talk about that section 25 of the charter that we've been talking about. Welcome back to Canadian Justice, where we're discussing a case headed to the Supreme Court of Canada to address the question of whether Indigenous self-governments are subject to charter scrutiny. So if the Charter of Rights and Freedoms applies to the conduct of those Indigenous self-governments. Now, what the Court of Appeal in the Yukon found about this, Jesse, was that Section 25 Section 25 of the Charter shielded that Indigenous self-government in this case from charter scrutiny. So what exactly is Section 25 of the Charter? A lot of people probably don't know about it. And how was it applied in this case?
Right. So it is a little known provision, and hasn't really gotten much judicial treatment. And the few times where it has sort of come up in the Supreme Court, they've sort of dealt with the case on another basis and left that issue to another day. But the provision essentially, I'll read it. It says the guarantee in this charter of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal treaty or other rights and freedoms that pertain to the Aboriginal peoples of Canada. So in essence, it means that Aboriginal rights and freedoms are not to be affected by the enactment of the charter. And so there's a debate in the literature and certainly in the case law a little bit about what exactly does that mean. So there's a camp there that say, this is really just an interpretive provision. They'll use the expression interpretive prism. I'm not sure what that means, but that is camp number one. Then you have the other camp, which is that this is more substantive and has a bit more teeth, a bit more bite, and that it serves to shield Aboriginal rights. That the charter can't be used to remove them or impact them in any way. And so there's a middle position, which is the position that the CCF is advancing, which I assume we'll get into in a little bit.
Yeah, so why don't we get into that right now? Bryn, what exactly is the CCF arguing about how Section 25 of the Charter should be interpreted this case? What is that middle path?
Yeah. So the CCF is arguing that Section 25 is a guarantee to Indigenous peoples that the Charter will not be used as a sword by non-Indigenous persons to undermine the specific and distinct collective rights of Indigenous peoples in Canada. So CCF is asserting that it is a shield in part, but not a complete shield, as the court found below. And specifically, the CCF is arguing that it does not deprive Indigenous individuals from making charter claims against an Indigenous government or shield all decision-making of Indigenous governments from charter review. It is really about protecting against challenges by non-Indigenous persons to kind of differential treatment that arises from the collective rights of Indigenous peoples in Canada.
Bryn, can you give me an example of how this argument might be applied, how the shield not sword argument might work in practice?
Sure. So, I mean, there's a couple of examples that kind of come to mind when thinking of it being a shield. So you could have, for example, a non-Indigenous person, changing the facts in this specific case a bit. You have a non-Indigenous person that resides on reserve or settlement lands and brings a Section 15 challenge on the basis that they're not able to vote or run for office in the Indigenous government at issue. We would say that type of challenge is shielded by Section 25. You could also have challenges by non-Indigenous persons to differential treatment in terms of access to hunting or fishing as a result of Aboriginal and treaty rights. Again, something we would say is shielded by Section 25.
Jesse, is there anything you want to add to that in the minute we have left?
Yeah, well, I would just say that I would say, Section 25 was meant to protect other rights. It was not meant to deprive Indigenous peoples of the rights in the Charter, right? So the way to see it in a way is sort of like what Section 26 of the Charter does, which is to recognize that the Charter isn't exhaustive. It doesn't contain all the rights and freedoms that one might have. And so Section 25 does something similar. It recognizes that, and it seeks to protect those rights, but it includes the Charter, right? Indigenous peoples also have Charter rights.
Mm-hmm.
They're not limited to the other rights that are protected.
Right, of course.
Yeah.
We've got to go to break, but we will be right back. Welcome back to Canadian Justice, where we're discussing a case headed to the Supreme Court about whether the Charter of Rights and Freedoms applies to Indigenous self-governments. Now, Bryn, this specific case involving Miss Dixon relates to her claim that she was discriminated against by the band because of where she lived. She didn't live on settlement land, a remote community in the north of the Yukon. Instead, she lived in Whitehorse because of her son's special needs and this need to be close to the hospital. And as a result, the band wouldn't let her run for council. Now, the CCF, we don't actually take a position on whether or not this was discrimination or not, but I think that our viewers may want to know how that argument works, because there is a Supreme Court case that determined that the place of residence can be the basis for a claim for discrimination by an Aboriginal person or brought by an Aboriginal person. So can you tell me a little bit about that case and how it's relevant here?
Sure. So you're referring to the Corbiere decision from the Supreme Court of Canada. And this case found that a requirement in the Indian Act that band members be ordinarily resident on reserve in order to vote was unconstitutional because it breached Section 15 of the Charter. The court found in that case that this distinction perpetuated the historic disadvantage experienced by off-reserve members, and that they had important interests in band governance and band assets, which this distinction through the Indian Act denied. This case has been relied upon in numerous lower court decisions relating to differential treatment between on and off reserve members of First Nations under the Indian Act. And it was, as I said earlier, it was dealing with limited to the Indian Act and First Nations under the Indian Act. But the finding that Section 25 provides a complete shield could effectively reverse Corbiere for any First Nations that are asserting that they adopted requirements pursuant to an Aboriginal right to self-government, whether they have a self-government agreement or not, or whether or not they're under the Indian Act. So, I think this decision could have significant implications for Corbiere and other cases that have relied upon it in terms of those types of issues that may arise in the future.
Now, Jesse, the CCF is an intervener in this case, but we're not the only intervener. There are several. So who are some of those others, and what are some of their positions?
Yeah, so of course there are sort of the attorneys general which get to intervene in the Supreme Court as of right. So there's a couple of those intervening. Among the groups that sort of applied for intervention, there were 13 in total, and 10 of them got in. 7 of them, I would say, broadly speaking, because of course interveners cannot speak to the merits of a case, but broadly speaking, advance a position on the legal issues that is similar to the respondent in this case, so the First Nation that's at issue. So the arguments, there's various arguments, but I think the thrust is that the Charter should not apply in a case like this for various reasons, and they advance. They're all unique positions. And then there are three interveners. So the CCF and two other Indigenous organizations, including the Congress of Aboriginal Peoples, advancing a position that broadly is aligned on the legal points with the appellants. So generally arguing that the charter should apply to Indigenous governments. And again, there's differences on the positions about the law between the interveners, but that's sort of the breakdown. And so what the CCF is bringing, I think, that is unique from the other interveners is that the CCF is trying to situate our understanding of Section 25 in its context. So in 1982, when this provision was adopted, what was the purpose? What were the framers looking to do with this provision of the Constitution? And so we're looking at conversations that were had by Pierre Trudeau that sort of align with the position that we're bringing. So we're inviting the court not to just adopt a position about what Section 25 does or means in the abstract, but to look at what the compromise was in 1982.
Exactly. Really fascinating. I want to thank you both so much.
Thanks so much.
We've heard today about the fascinating case of Cindy Dixon from Whitehorse and her desire to serve her community. And we've heard about the question going to the Supreme Court. Does the Canadian Charter of Rights and Freedoms apply to Indigenous self-governments? Do you think the Charter must apply everywhere to all Canadians? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.